to have a valid delegation of duties, you have to have the delegate assume the duties. And so for an assignment, what makes the assignment valid is the notice to the other party. When we're dealing with the delegation, what makes it valid is that the delegate has to assume the duties or similar language. So we would be looking for those kinds of terms in the delegation. Was the word assumption used? Was the word I assume the duties? Was the word used I take all responsibility over from the delegator? Words to that effect. That's what you need in order for the original party to not be responsible for performance under that contract. Okay, so to give an example, I delegate my duties to Joe. And as part of that, I'm just like, hey, Joe, are you going to go ahead and paint the house for me? And that's all I do. That would likely be seen as a declaration of duties. The delegate has not actually assumed the duties or done anything under the delegation to proactively take on those responsibilities. So when the house is not painted, you, the other party to the contract, can still come after me for non-performance. Okay. However, if I delegate my duties to Joe and I say, Joe, will you assume the duties of painting the house? And Joe says, yes, I assume the duties of painting the house, or similar language. Now the delegate is legally liable for the performance. And if the house doesn't get painted, you, the other party to the contract, can only come after the delegate. You no longer can come after me. So again, with the delegation, it is the language that is extremely important in terms of who is legally liable for non-performance under that contract. Okay, so we want to make sure, again, if we're working with a client, that we make sure the language is used. So legally, everybody's intentions are actually supported by the delegation. But at the same time, we may have clients that will come in and say, oh, I delegated my duties to someone and they didn't do them, but now I'm being sued. We need to ask appropriate questions or see documentation to see whether or not we can make the argument that it was a legal assumption of duties, or was it in fact just more a declaration of duties where the original party is still responsible on that contract. Okay. So you avoid delegation basically the same way you avoid assignment. You put in anti-delegation clauses. And courts will generally enforce those. Some courts have been willing to allow an exception if the duties are completely impersonal in nature, like if it's not because of the person's particular skill or whatever. Usually, but not always, assignment and delegation will occur together, or anti-assignment and anti-delegation will occur together, but they do not have to. They don't. Just because you have one, it doesn't automatically mean you have the other. However, the modern trend in courts seem to be that if their assignment is specifically allowed, or if an anti-assignment clause is included, then the court assumes that either delegation is allowed or anti-delegation is also included in that contract. So it goes back to just how important it is when we're drafting the contracts to make sure that we are including the terms that our client wants in that contract. Because if we're not specific and they end up in court later on a breach of contract, and it's unclear to the court what's going on with the assignment and delegation, what our client's intentions were may not be what the court finds. So we want to just make sure we're protecting our client and their interests. Okay, so that's the end of assignment and delegation. And now we move into third-party beneficiaries. So again, we're still talking about privity of contract and the idea that only the parties to the contract have any rights and obligations under it. We've already talked though about assignment and delegation, which would allow third parties to either have rights to enforce or have a duty to perform under the contract. and then the third party beneficiaries. And so again, you and I enter into a contract, but there's a non-party to the contract that has rights to enforce. So intended third party beneficiaries include donee beneficiaries, which again is the life insurance contract that I talked about earlier. Okay. So you and I enter into a contract with the intent that my child will receive a benefit from this contract. My child is not party to the contract. You, the insurance company, and I are parties to that contract. My child would be a donee beneficiary under this scenario. So I am the promisee because I am the one the promise has been made to. You would be the promisor because you are the one that has agreed that the payment or benefit will go to the donee beneficiary, my child, and then the donee beneficiary would of course be my child. That's who's going to be receiving the benefit. If you, the promisor, fail to perform, fail to make payment under that insurance policy, the donee beneficiary can sue you. So again, normally the only people that can sue on a contract or failure to perform a contract is a party to the contract. And in a intended third-party beneficiary situation, such as a donee beneficiary, the donee has the right to enforce the contract. Okay. The other type of intended third-party beneficiary is what's called a creditor beneficiary, which is a very, very specific type of situation. But if you work for banks, if you work for mortgage companies, loan companies, I'm going to use a purchase of a car situation, so car dealerships, you're going to see this situation potentially, or you're going to take action to avoid this situation. But what you have to have a creditor beneficiary situation, and again, this would be a situation where somebody who's not a party to the contract can enforce it. So for this very specific situation, I'm going to give you the example. I am the debtor. I'm buying a car from you, the creditor, and I am paying you money for the car. And I am making payments on the car. So I have the car. I'm paying you under our agreement. I then sell the car to another party. The new buyer, person I'm selling the car to, agrees to pay the remainder of the money to you. If the new buyer does not pay, you as creditor can go after the new buyer for payment. Okay. You have become a creditor beneficiary under the contract between the new buyer and me. So again, I'm going to say that one more time because I think this one's a little confusing. Again, they have a chart in the book on it, so I think that's helpful to look at. So again, creditor beneficiary, debtor, me, I borrow money from you to purchase something. I have the item. I'm making payments on the contract, the loan to you. I then sell the item to someone else. The new person, the new buyer, agrees to make payments to you. Okay. If the new buyer fails to make payments, you, the creditor, can go after the new buyer because you are the creditor beneficiary of the contract between myself and the new buyer. Okay. That's what makes you the creditor beneficiary. You are not a party to my contract with the new buyer, but you are the beneficiary of it because you are supposed to receive the payment, and you can enforce that payment against the new buyer. You can also enforce payment against me. So as a creditor beneficiary, you can go after either the original party to the contract, me, or the new buyer for recovery of the money that is owed you. But you can only collect the total amount you're owed once. So you can't get the whole amount from me and the entire amount from the new buyer. You only get the entire amount once, but you can collect it from either one of us. Okay, so those are the intended third-party beneficiaries. So people who are not parties to a contract, but under certain circumstances have rights to enforce under that contract. And then the incidental third-party beneficiary is a situation where I'm going to tell you what they are and explain it to you, and then just basically say, don't worry about it, because legally an incidental beneficiary has no rights to enforce. And so this would be someone who unintentionally benefits. They weren't set out to be a beneficiary of the contract. So they're not like my child on the life insurance policy, and they're not like the creditor who loaned me money to buy the car. These were not people that were intended to be any sort of beneficiary. And they give an example on the bottom of page 168. So I'm just going to go over that with you, just so you understand it and don't get it confused with the other types of beneficiaries we've talked about. So Heather owns a house on Residential Street. Her neighbor John owns the house next door. Heather hires a painting contractor to paint her house, but the contractor then breaches the contract and doesn't paint it. Now, had the house been painted, John may have benefited from that, because Heather's house looking nicer and having more curb appeal can help the value of his house or the attractiveness of his house. But he would only be an incidental, unintended beneficiary. He would not be able to sue the painting contractor for failing to paint Heather's house. Only Heather can do that. So that's an example of an unintended incidental beneficiary, someone who might receive a benefit, but they're not an intended beneficiary. And under the law, only intended beneficiaries, like the donee or the creditor, are people who can actually enforce a contract. Okay, so the last part of the chapter talks about covenants and conditions. And so this really has nothing to do with the with everything else we've talked about in chapter 7, but this is where the author included these concepts. So this is where we're going to talk about them. So a covenant is an unconditional promise to perform. Okay. So everything I've been talking about up to this point, and all the various examples I've been talking about, have been covenants. I promised to sell you my car and you promised to pay me $1,000. Those are covenants. They're unconditional promises to perform. And if one of us doesn't perform, the other one of us can take us to court for breach of contract. Okay, it gives you the right to sue. So a covenant is just the terms of the contract, basically, but they're unconditional or unqualified. It's just, there's nothing that has to happen that triggers our obligation. It is the promise that we have made to each other. A condition, legally speaking, is a qualification of a promise. And if the condition occurs, then the promise becomes a covenant, meaning it is enforceable under the law. And if a party fails to perform, then you can take them to court. Okay, so that's a covenant and a condition. So we have a couple different types of conditions that we're going to talk about. Conditions precedent or precedent. And again, that word gets pronounced both ways in this context. That is a condition that has to occur before the party is obligated to perform. Okay, so a condition precedent, it's a qualification of a promise to perform, and that condition has to occur before the obligation to perform exists. Okay. So an example, you are a soon-to-be graduate and you come into my office for a job, and I make you an offer provided you graduate. So if you graduate, we will hire you. You graduating is the condition precedent. Once you graduate, my hiring you, theoretically, is now an enforceable promise. Okay. So that's all we mean by condition precedent, whereby the terms of the contract itself, something has to happen to trigger the party's obligation to perform. You generally speaking, actually, scratch that. Conditions precedent or precedent can be based upon a party's personal satisfaction. And so that would be something along the lines, you're going to paint a portrait of me, and if I am satisfied with it, then I will pay you for it. So our contract is, you will paint me and I will pay you for it, but the condition precedent is that I have to be satisfied with it. And the law will look at two different types of tests. The personal satisfaction test, which is, like it sounds, completely subjective. Okay, so that's completely subjective, personal satisfaction.